key takeaways. Let's start with you, Laura Smalley. What are the most important things you would like our attendees to leave here today with from your presentation?
I think it is that basically the case law is always evolving, and that the Federal Circuit and the district courts look very closely at your proposed damages case to see, whether it fits within things that they've approved before and whether you've really addressed all of the relevant factors. So I think you need to start early on in the case, get an expert involved early, and get all the discovery that you need from the defendant, and develop your own evidence that, based on the case law you've hopefully reviewed early on in the case, satisfies each element that the federal circuits and the courts deem necessary to not get your testimony or your damages case excluded or dismissed. So for example, if you're going with comparable licenses, be prepared and have your expert address all the factors why they are technologically and economically comparable. If you're going down the cost approach, have all of the data necessary and address any potential criticisms of your method up front, rather than have it, end up getting decided on a motion to exclude or motion to dismiss.
Lauren Kindler, your turn.
Yeah, so before I get into my key takeaways, I'll just say I definitely agree with what Laura said about getting experts involved early. I find that when I'm involved in helping with the discovery process, I think that can be very helpful for the case to make sure that we get all of the information, all the production materials that we need to make our case. And then I would say, at the end of the day, so when we're evaluating royalty damages in patent infringement cases, we're really looking for the most reliable indicators of value of the patented technology, and there's really no one-size-fits-all rule to assessing whether certain types of license agreements can be relied upon, for example. And the most important thing in making that determination is to demonstrate the economic and technical comparability and use sound economic justifications for any adjustments that you make or lack of adjustments that you make to reach a conclusion of comparability. And then in the alternative, there are many other accepted methods that can be used to isolate the value of the patented technology. And from my perspective, and what I always try to do, given the careful scrutiny of the courts on damages methodologies, I think it's always important to have more than one methodology to the best of your ability and more than one anchor for a damages expert's opinion. So in an ideal situation, you'd have multiple data points or multiple anchors that all arrive at the same common range of value that can be attributed to the patented technology. That way, in the event a piece of your analysis gets excluded for any reason, you still have other remaining anchors for your royalty conclusions.